Dame Vera mentioned just a lot there that I think hopefully resonates with a lot of us here, but one of the things that I particularly noted her saying was how important investigation and reinvestigation of cases is. Rachel Diosavilla and I attended a workshop in Spain last year with Marty Tankleff, who spent 20 years in prison for murdering his parents before being exonerated, and then he went on to become a lawyer himself and now has his own wrongful conviction project. But he maintains that reinvestigation is vital to uncovering wrongful convictions. So post-conviction work for lawyers is a very different beast entirely to the regular work that lawyers do. And it takes a whole different approach and, dare I say, level of commitment that lawyers like Michael O'Keefe and Rani Rego, who you'll hear from today, embody. Next up, we have Professor Kent Roach. I first met Kent at the Innocence Network conference in Phoenix, Arizona in 2023. He was, and I understand still is, on a mission to visit every Major League Baseball stadium in Canada and the US. And it was taking him years, but he's been involved in wrongful conviction work much longer.
Thank you very much for asking me to speak to your conference. I really wish that I was with you, in part because it is literally freezing in Canada as I am giving this talk warm in my messy basement office. So I've been asked to talk to you about the new Miscarriage of Justice Review Commission in Canada, and I'm very happy to do so. The subtitle could be, was it worth its weight? Or it could also be careful what you wish for, depending on how pessimistic you want to be. So let me start with some background and also maybe stress the more positive parts of Canada's decision to move away from relying on our federal Minister of Justice. In Canada, criminal law is exclusively federal. So we used to allow the federal Minister of Justice to order a new appeal or even a new trial in cases of miscarriages of justice where ordinary appeals had already been exhausted. Now that power will be given to this new Miscarriage of Justice Review Commission. A couple of things. One is there was a lot of preparation and frankly delay, and there is still delay in Canada because the commissioners have not been appointed and the commission is not close to up and running. So the first of our 7 public inquiries that recommended that we get the federal Minister of Justice out of this sphere was in 1989, so even before the creation of the CCRC in England. And as I said, between 1989 and 2008, 7 public inquiries in Canada recommended that the Minister of Justice be replaced by a commission of inquiry. Now, in 2002, there were some reforms to our process. It came from what might be a kind of an embarrassing spectacle where the Minister of Justice, Kim Campbell, initially denied David Milgaard's application for a new appeal. And then on national television, the late Mr. Milgaard's mother, the late Joyce Milgaard, buttonholed Brian Mulroney and pleaded for her son son. And within 4 months, there was an appeal that eventually led to Mr. Milgaard's exoneration. I tell you the story because our bill setting up the Miscarriage of Justice Review Commission is named after David and Joyce Milgaard, and appropriately so. But this was embarrassing because it made clear that if you wanted to get a remedy from the elected executive, you better play politics. There was a subsequent inquiry that unsuccessfully tried to get to the bottom of why Kim Campbell, the Minister of Justice, after having just denied David Milgaard's application for a new appeal, once her boss, the Prime Minister, Brian Mulroney, got onto the file, suddenly referred his case to what was a successful appeal in our Supreme Court. So this really kind of reveals, I think, one of the problems with relying on the elected executive is that you really do have to play politics and play politics successfully to get a remedy from the elected executive. Having said that, the fact that there was a remedy for Mr. Milgaard should not be forgotten. And the power of mothers when it comes to campaigning for the wrongfully convicted is not to be underestimated. So in any event, this revealed some of the problems with relying upon the elected executive. In 2002, in response to the spectacle of the Milgaard case, there was more legislative structure given to the elective executive, exercising the residual of the royal prerogative of mercy. But it actually set a very high standard, which was the Minister of Justice could only order a remedy if there was a miscarriage of justice probably occurred, which I would say is a higher standard. So the best thing I think about our new Miscarriage of Justice Review Commission is that the standard has been lowered. So now this commission will be able to order either a new appeal or a new trial if they conclude a miscarriage of justice may have occurred and it is in the interest of justice to do so. In addition, there is clear legislation that says a miscarriage of justice may have occurred even though the innocence of the accused is not established. In non-DNA cases, and in cases where DNA evidence has not been properly collected and retained, it frankly may be impossible to prove innocence. The Americans require proof of innocence, but as I argue in my new book, Justice for Some, that really is an exceptional case that reflects the use of mass imprisonment in the United States. So I take this as the biggest accomplishment of our new legislation, that it will be easier for a victim of a wrongful conviction to get a remedy from the new commission because of this lower standard, which also makes clear that innocence, it does not have to be proven. Now, I know in Australia, you of course have rights of second and subsequent appeal in most states. But one of the concerning things I document in my book is the most recent legislation in both in Western Australia and in Queensland seems to give preference to proof of innocence. And part of the politics of this, and I appeared both in our House of Commons and Senate committees while they were debating the book, the bill, was our more conservative party in Canada was attracted to the American style proven innocence requirement. So I think that this is something that you really need to guard against in Australia, that there may be more of a political consensus around proven innocence, but you need to think about how many people who are victims of wrongful convictions and miscarriage of justice may not get a remedy if the standard is proven innocence. So that's one thing. Another good thing about the new commission, and this really came from public consultations done by Justice Laforme and Westmoreland Traore. I was their director of research, so I was present at all of the public consultations. Our first public consultation were with exonerees. And the first thing they said to us, because the government was calling this the Criminal Case Review Commission, the first thing the exonerees said to us very clearly was, we don't want a criminal case review commission. Why? We're not criminal cases. We're people who have families. And we don't want our convictions to be the subject of a desktop review. We want them to be investigated. And David Milgaard spoke to us 4 times shortly after he tragically passed away prematurely, as too many people who have spent, in David's case, 23 years in prison often do. He was really one of the ones leading the charge that we didn't want it called a criminal case review commission. So I think that you need to think about what the title is. Now, who is going to be on our commission? This is where things, I think, get a little bit more dicey. We recommended, and when I say we, I mean Justice Laforme and Westmoreland Traore, I was helping them, that there should be 9 to 11, and there should be at least 1 Indigenous and 1 Black commissioner. The government said no. And we have a commission that can be as small as 5 commissioners and as large as 9. As I said, our government, even though this legislation was given royal assent a year ago, has still not gotten around to appointing any commissioners, but I'm guessing that they're only going to appoint 5. The other thing that we recommended against was that the commissioners should not be eligible for reappointment. It was very important for us that if the commission is going to have the power to, kind of check the homework of the judiciary, they should be treated as much like the judiciary as possible. And of course, we don't reappoint judges. So we said that there should be 1 term, and that is it. There's now going to be reappointments, and there is a possibility that there will only be 1 full-time commissioner, and that person will also have to be the chief executive officer. So we may very well have a smaller commission compared to New Zealand, which is a much smaller country, both in terms of population and size. So I think one of the things that you have to think about in Australia is the challenge of your geography in both Canada and Australia, the geographical challenges of a national commission are very extreme. But I also understand that many states may be unwilling to have their own commissions. And as I said, in Canada, it wasn't even an option because all criminal law is subject to federal jurisdiction. Like the New Zealand Commission, our commission has a mandate both to review individual applications and to do systemic reform. But again, this will depend on the adequacy of its budget. And one of the things that I would be cautious about, I think David Hammer has also talked about this, is I think a commission may not be in the best place to do systemic reform work. I think innocence projects, innocence organizations are in a good place to do that. But that doesn't mean that the commission should not work with researchers and organizations. And indeed, we recommended that there should be an advisory committee, partly to lobby to ensure that the commission has an adequate budget. Because, of course, the English experience, which you will also hear about at this conference, suggests that these commissions are vulnerable to budget cuts. As I said, the new referral standard is a miscarriage of justice may have occurred, and it is in the interest of justice to refer it, even though the interest of justice is the New Zealand standard and our standard is the Scottish standard. We recommended that interest of justice gave too much flexibility to the commission. If you've been wrongfully convicted, you're not likely to have confidence in a commission, even if you call it independent, which is part of the justice system, that is going to conclude that a remedy is not in the interest of justice. So for us, that was too vague. So that's something that you may want to consider. There was a lot of debate about whether sentencing should be included in the mandate of the commission, as it is in England and Scotland and New Zealand. We recommended that it should. The government decided that it was not within the remit of the commission. And a lot of people, including defense lawyers, actually advocated for that, saying, look, the commission's going to have enough work to do on wrongful convictions. One of the things that is included, though, are not criminally responsible verdicts, which can result in indeterminate detention, and dangerous offender status, which also relates to indeterminate detention. Another issue is what powers does our commission have? Our commission will have the same powers as the federal minister of justice, the elected executive, does, and these are the powers of a public inquiry, which are quite broad powers of subpoena and compelling testimony. So that may look good. But one of our concerns in the consultation was that prosecutors and police told us that right now we're giving material to the federal minister of justice, partly because we trust him, without claiming privilege. And they said, one of the issues may be that if we don't quite trust this new commission, we may claim privilege. We may not give them material that is, say, the subject of police informant privilege or solicitor client privilege. And so we recommended that, like the English Commission, that the Canadian Commission have powers to have access to all relevant material, regardless of claims of privilege, and that it kind of attempt to preserve that privilege as much as possible. Again, the government rejected this recommendation, and so I worry that our powers are perhaps less robust than the English Commission's powers, and I worry that police and prosecutors may resist some disclosure of relevant information. Our new commission will have to prepare annual reports, and that will include information about delay. One of our huge problems with the elected executive is it can take 5 to 6 years for them to make a decision. Hopefully, it will go quicker. Our new commission, although it has not been appointed, will sit outside of our capital in Ottawa. It'll be in Winnipeg. It will have to issue annual reports that will report on delay, but will also give demographic and information about disability and income with respect to applicants. So I think that's something you want to think about, because you want a commission to facilitate better understanding of who it is that are victims of miscarriage of justice, who it is that applies will get a remedy. And then finally, like the New Zealand, our commission is required to give reasons for its decisions. And of course, all of these commissions, even if they're more generous than the elected executive, do not grant remedies for the majority of applicants. And one of the things that I find worrying is the New Zealand Commission really seems to be narrowly interpreting its requirement to give reasons. And I don't at all underestimate the difficulties of giving reasons, both because the commission has limited budget, but also because of privacy concerns. So that's another thing. And then finally, I would also commend to you is our commission has powers to provide a wide degree of support for applicants who are in need, including even housing support. And again, that was something we heard from the exonerees, we heard from the Innocence organizations, and this was what the government actually followed this recommendation from Justice Laforme and Westmoreland Traore. But I'll end with that power, and indeed all of the powers of the Canadian Commission will depend on the adequacy of its budget. And even though the government that created the commission may feel a degree of ownership towards the commission, the English experience suggests we have to worry about this in the long term. And so a commission may well be an improvement over the elected executive, but it is not a panacea. It doesn't mean that you don't need innocence organizations and defense lawyers to also work on this. And it doesn't mean that you do not have to be vigilant, because even if you have a good commission at one point in time, there are no guarantees that it will be adequately funded and that the right people will be appointed to it down the road. So I wish you luck with your deliberations, and certainly an Australian commission I think would be an improvement. I'm not sure I would get rid of the right to second and subsequent appeals. I think you want to have a kind of fail-safe, because the last thing is a commission's is still an executive body, and if it makes mistakes, as any human institution will, and as the English Commission has recently, we have to worry that those mistakes are only reviewable under administrative law, which is fairly deferential. So thank you very much for inviting me to talk about the Canadian Commission, and I wish you the best of luck in having an Australian Commission, which hopefully even has more safeguards than the Canadian Commission.